Good afternoon. Welcome to the next event in Leeds Digital Festival. Leeds Digital Festival, which is ongoing at the moment with 300 events going on, the largest tech festival in the UK, and really having now an international standing. I'm Paul Berwin, and today we're working jointly with Page White and Farrer and Virginia Driver from Page White and Farrer. Her colleague Tom Woodhouse was to join us, but he's unwell at the moment. But the content is sort of joint content between Virginia and Tom. So we're looking at unlocking the value of intellectual property, and we'll each deal with different aspects of that. And I hope that overall it'll give you a good balance and a good overall picture. So we will kick off now. We've got, there is a Q&A panel at the bottom, so any questions which you've got, please put them in there and we'll look at them as we go along. We'll either answer them as we go along or we'll answer them at the end. So if you like to do that, that would be great. For myself, so I'm Paul Berwin, so I'm head of digital and commercial at Berwins. We're based at the platform, as are Page White and Farrer. Page White and Farrer are also in London and Munich, but obviously Leeds is the most important office of all those. We're both on the Leeds Tech Map, which you'll see here, and so both parts of the ecosystem that forms part of Leeds Digital. So I've been involved in working for software and digital media companies since the mid-1990s. So the IP around those issues has been part of that. So that's a long time involved in that. We've got a team here at Berwins who have experience in various areas relating to tech and the IP that we deal with, specifically dealing with tech. This also comes up in the context of business sales, where businesses, particularly tech businesses with IP assets, have to deal with those. And so we deal with a lot of transactions where that's a major element. And so the handling of that is something that we deal with. Okay. So we're talking about unlocking the value of IP, but to unlock the value of IP, firstly, you've got to get it locked up. So we're going to be talking partly about how you do that, so how you protect it in order that you can then capitalize on it. So formal rights can be dealt with by licensing, by assignment, and by other means of sharing and collaborating. Where there are not only formal rights that you can license, including methodologies and things of that sort, and in preliminary discussions, then you need to rely on contracts, and particularly non-disclosure agreements. So those are key, but you need to rely also on what in data protection terms we'll call technical and organizational measures, because once information is out, it's out. So formally, what are intellectual property rights? So there's patents, which Virginia will be talking about in detail, copyright, which I'll deal with, design right, which isn't something we're dealing with today, trademarks, which I'll also talk about, database right, again, not for today, and confidential information, which I mentioned before, and Virginia will deal with as well a bit later on. So principally, I'm looking at copyright and trademarks. So in the tech sector and in the creative sector, so we need to look at what rights can be protected, and whether you've got the rights to use those yourselves in your business. So the fact that you can access something doesn't necessarily mean that you can use it. The most obvious example is photos and so on websites. The fact that something is on a website doesn't mean you can then copy it. Much misunderstood from that point of view. So you need to have a good idea who owns the rights, and be aware that sometimes that's not who you think it's going to be. So sometimes it may be a contractor who's created some work for a company, not the company itself, and that can lead to its own issues. The other point to remember, and this is a sort of key phrase to bear in mind, is that what you protect isn't the idea, it's the expression of the idea. So this is really important in copyright. So an idea can be copied, but it has to be done in a different way. But the actual way is protected. Okay, so looking at copyright. So copyright is not a registrable right. So it's something that arises automatically. So the ways that it might arise, it could relate to software, words, sound, pictures, effectively something that involves a creative act. So it doesn't have to pass the tests that patentability needs to pass, which again, Virginia will talk about. So it's to protect something from being copied. You've created it, you've put your intellectual capital into it, you have a right for it to be protected. So copyright, if something has been created of this sort, then generally speaking, it's protected for 70 years from the date of creation of the right. That's slightly different in terms of film and dramatic and literary works, but for the purposes of tech businesses, creative businesses, it's generally 70 years from the date of creation, and usually that is dated from the end of the year in which something created, so you don't have to tie down the actual day that something's been written. It's in software, it's the principal right, but definitely not the only one to be bothered about, and patentability is something which Page, White and Farrer will look at in detail. But from the point of view of marketing and branding and so on, you'll also look at other rights, particularly trademarks, which I will talk about shortly. So how do you protect something that you can't register? So you do it by recording the date of creation, by licensing, by contracts that confirm the date of creation, by notification, so by letting people know, sometimes by using the C mark, sometimes less the case now, but it used to be the case that people would post manuscripts to themselves, so that there was a postmark on an envelope and do something of that sort. So there needs to be some means of evidence, and obviously some of that will not be that clear, and sometimes that's led to litigation. And if there's one thing you want to know, is you don't want to get involved in litigation. It's uncertain, it's expensive, and so you want certainty. Okay. So how do you go about licensing software? So this is something which at Berwins Digital specifically is at the center of what we do. So you'd license it by contracts, by whether it's a licensing agreement or a SaaS agreement or something of that sort. It needs to be clear what you're licensing, what you're not licensing, what you have a right to license and what you don't. These issues become really, really contentious in some cases. And I wouldn't normally talk about court cases, but this is a real biggie. So SCOTUS is the Supreme Court of the United States. So litigation had been going on for 10 years between Google and Oracle over the rights to use the API to Java. So Oracle owned Java, hugely valuable. They'd acquired it when they acquired Sun Microsystems. And when Google was creating Android, and they were doing it in a hurry because they knew that they had to do it to compete with Apple, with iPhone and so on, they were having code written, but they wanted to be able to interface with Java. So they wanted to be able to access the Java API. And rather than acquire the right to do that directly from Oracle, they literally copied the code. They copied 11,500 lines of code from the Java API and used that in order to accelerate the development of Android. Now, on the face of that, that sounds like a breach of copyright. It sounds as if it's something they shouldn't have been doing. And these giants have been in litigation for the last 10 years about that. But that litigation has now finished in April. Google was successful in claiming that they had not breached Oracle's rights by doing that. It's quite an unusual and possibly unexpected decision. It feels like it's a policy decision, because the cost, if everybody had to pay to use Android and pay license fees to Oracle, that would have been a huge, huge cost. So the Supreme Court decided that it was a fair usage rather than a breach of copyright. Oracle not happy with that, Google very happy with that. But it does show that things are rarely as black as white as you think they should be. And it has cost both those companies billions, really, in litigation to get to this point. So what's copyrighted generally is source code. Sorry, can you go back? So what's copyrighted generally is source code. So object code won't tell you anything very much because it's ones and zeros. It's not human readable. But source code is what needs to be protected. And sometimes within licensing arrangements, there's arrangements whereby source code can be released. For instance, if the licensor goes bust or something of that sort. There are issues to be aware of with open source software, so applications which are used within the development of software. So you have to understand open source software, not to be discussed here in detail, but we can help with that if you need to. But open source, if it's licensed under the GPL, the General Product License, often attracts what's called copyleft. So it means that whatever you produce using that is also open source, and so anybody is entitled to the source code for that. So that is a viral license. So the use of open source should be very carefully recorded and monitored. Okay, next. So I wanted to talk about trademarks. So trademarks are the important mark for protecting brands, really. So it's not to do with code at all. It may be to do with a logo or a name or something of that sort. So you can protect a name. You can protect a sign, so a logo. You can protect, in some cases, a slogan. Also shapes, colors, and smells. So the shape of a Coca-Cola bottle, the classic shape of a Coca-Cola bottle, is protected. We'll see in a minute that the red triangle of Bass beers is protected. Some colors in certain usage are protected, and even some smells. So trademarks are a real mark of origin. So something has to be original. It has to be not descriptive. So if you just call something by what it is, so the Yorkshire pies or something like that, it's a pie from Yorkshire, it's not going to be trademarkable as a word. It might be that the logo is trademarkable, but not as a word. And also that would fall foul of the geographical description. So if something just describes where it's from, then that's also not protectable as a trademark. Okay. Trademarks are also classified within 45 classifications. So it means you may have a name that is registered within one classification for use in, say, computer software or something like that. That name might also be registered for use in woodwork or something completely separate. And one wouldn't be a breach of the other one. You can have a series of trademarks, so you may have a logo which you may use in different formats, so in different colors or something of that sort. You need to actually be using or intending to use trademark. So the actual use is quite interesting when we come to talk about patents, where the opposite effectively is the case. Trademarks are also national. So we've I had a conversation today with someone who wants to register a trademark in the UK, but they also do a lot of business in the US. So they need to register it in the US as well, and potentially in other markets. There is an EU trademark, which is very useful, very valuable, and there's a good system for dealing with that. And the UK, of course, is now excluded from that. So a UK trademark doesn't become an EU trademark. So we've got a bit of damage done by that. Trademarks are relatively inexpensive. The official fees for doing it is only £170, which gives you 10 years of coverage, a little more if you're in more categories and so on. So it can give you really high value for a really modest cost. Okay. So just some examples. So I mentioned the trademarks are for 10 years. So that's infinitely renewable. So the oldest UK trademark goes to 1875. It's this one, Bass Beer, the red mark. And if you look very carefully at that slide, you'll see it says trademark on it. So that's been going since then. So every 10 years, they'll pay the same fee, probably. Fees haven't gone up in the whole time. In fact, they've gone down the whole time that I've been dealing with trademarks. So there is massive value in that. Okay, so here's something else. So the shape of a chocolate bar. There's been litigation going on for years and years and years between Nestle and the owners of Cadbury's, whose name escapes me, but so Kit Kat have tried to register the shape of the Kit Kat, specifically the four-finger shape of the Kit Kat. They have been unsuccessful so far in doing that, and they've kept doing it. Cadbury's have kept opposing it. So that's been going on. And you can think about other things in the world of chocolate, which might apply. So Toblerone is a very specific shape. So there's a trademark on that shape. But then look at the next slide that we've got here. I think we missed one. Right. Well, let me tell you about this one, because I think we've missed one anyway. So the colour purple in relation to Cadbury's dairy milk has also been contentious. So Cadbury's tried to register that colour relating to chocolate. Nestle opposed that. They failed, but they keep trying again because the grounds for failure were quite a technical ground. So they're trying to say, well, everybody associates this colour with this chocolate bar. Okay. So what isn't IP? So certain things which people think are intellectual property and they're not in the same way. So domain names are not formal intellectual property rights. Company names, so the fact that you've got a company in a particular name, you might be able to register a company called McDonald's Hamburgers, for instance, but that doesn't allow you to call your hamburgers McDonald's, because McDonald's will stop you doing that. Using your own name isn't necessarily something you're entitled to do, just because, again, because your name is McDonald doesn't mean you can say, well, I'm McDonald's, so I can use this name to sell my McDonald's hamburgers. So be aware that those don't give you the same kind of protections as the rights that we've been talking about and that we'll talk about shortly. So IP is all around you. So in music, for instance, so if you're watching a film, so there's music going on, there are performances, there are directors, there's all sorts of layers of different things going on. Similarly in books, in games, In some cases, IP is easy to copy, so you need to be able to prove the origin. So you need to understand the value in IP and protect IP. Some of the ways you can do that, just moving on. So non-disclosure agreements mentioned, making sure you don't give it away. So by not being too keen when the first customer comes along to sign whatever they put in front of you, make sure that it's your own contract. Getting assignments from contractors, so making sure that if someone else has been working on something, that the rights are yours. Licenses, again, really understanding the rights, asserting the rights, and safeguarding the rights. And then just to follow up on that, so be IP aware. So if you're aware of IP, you see IP all around you, and the way that it's protected, some ways that you think, well, how is that protected? Is that satisfactory? There's a lot of value in IP audits. So you can, in certain circumstances, get funded IP audits. So where the Intellectual Property Office pay for a large part of the cost of an IP audit. So certain cases, we do IP audits. Page White will also do IP audits, I expect, on different kinds of things. So Intellectual Property Office funding is about 80% of the cost. So that's pretty good. But you need to do more than just have the audit. You need to follow through on the audit and have a plan, and then resource it, because resourcing it is one of the problems. We've certainly had problems where people have gone through, had the funding for an audit, and then they say, oh, we really can't afford to do what we need to do. And so they're vulnerable until then. So core of value is there. So really understand it and protect that. So I'm going to hand over now to Virginia. If you've got any questions in the meantime, please put them in the Q&A. And at the end of this, we'll be talking about some other events that are going on, which may well be of interest to you. So over to Virginia.
Hello. I'm just trying to get my video working. Hopefully my audio is working fine. There we go. Hopefully everybody can see me now. So as Paul mentioned, thank you very much, Paul. As Paul mentioned, I'm Virginia from Page White and Farrer, a firm with offices in London, Leeds and Munich. And I specialize, I'm a European patent attorney, but I specialize in software, AI, and sort of really sharp-end tech around technology businesses. My colleague Tom, unfortunately, can't be with us today because he's unwell, and he works closely with me in the Leeds arena. So what I'm really going to, I am going to cover some of the points that Paul mentioned around patents in particular, but what I really want to focus on is one particular aspect of patent law, which often gets overlooked. And Paul mentioned, you know, this talk is about unlocking the value in your IP. And he pointed out that in order to unlock the value, you have to lock it up. But before you lock it up, you've got to make sure that you haven't somehow destroyed it in the process of doing what you think are the right things to pursue your business. So just quickly, a little bit of a recap over Paul categorized the different types of intellectual property. And I've got them in 3 different colors here. There's a type of intellectual property that you have to register, which means you have to apply to a government authority who will then grant you the rights that you are entitled to. That's in the light blue section. Then there's a piece in the dark blue section, which are rights which sort of semi-automatically arise, but you have to take steps to make sure that you have properly created them. And I'll talk a little bit about that. And then in the pink section are rights which are truly automatic. You don't have to do anything. You simply have to be aware that you own them. And Paul has covered copyright in depth. He mentioned database rights, but they all have this, share this property that they to some extent, they're the least troublesome rights in that you automatically acquire them when you create something, and then you just need to have awareness about how to use them. And Paul has covered that really well. So just briefly on copyright, one of the things I'm going to talk about today, the primary thing I'm going to talk about today is this golden rule. And the golden rule is don't talk about things. Don't tell people about your ideas. Don't give your ideas away. And then I'm going to talk about the real life constraints. Of course, you have to talk about your ideas and you have to give your ideas away in order to run your business. Now, copyright is one of those nice things because copyright, you can talk about it. You can tell people about your implementations. You can put your implementations into the market without any registration procedure, and you still have copyright. And it's just worth bearing that in mind, that everything I'm going to tell you now from here on in doesn't apply to copyright. So confidential information is one of those dark blue rights where you don't have to register it with a government authority, but you do have to take steps to make sure that you can rely on it. And confidential information is often, the shorthand for this is often referred to as a trade secret. It's a useful right, but it doesn't provide you with any exclusivity. It just gives you some protection about leakage. So if you have an idea and you keep it completely confidential, and actually in the context of software, it's far more likely that it won't be an idea. It will actually be a software implementation, perhaps something locked down in the back end of a server client environment. You can keep that as a confidential information, as a trade secret. And that gives you some rights over people who attempt to extract that or steal it from you. But it doesn't give you any exclusive rights over the idea which underlies it. The thing that gives you exclusive rights to the underlying idea behind your innovation is a patent. A patent is a monopoly right. It provides you with up to 20 years of exclusive protection for your idea. And when I say exclusive, only you are entitled to use that invention unless you actually grant somebody a license to use it. So they're extremely powerful rights. They're not restricted to implementation details like copyright was, as Paul was explaining. You can protect broad concepts. And you can protect software. Now, Paul said I was going to talk a little bit about software protection, and I am, but the primary thing I want to point out is that any software which is involved in a technical problem or is solving a technical problem can be protected by way of a patent, provided that it satisfies the other important criteria. So I think it's a very important message to take away, that you might have copyright and patent protection in the same piece of software. They're not mutually exclusive. So what are these other requirements? So just go back one. What are these other requirements for patentability? It has to be something which is new, and it has to be something which is non-obvious. So what do I mean by new? New means that it has not entered the public domain. Now, I'm going to go into this in a little bit more depth in a case study in just a moment. But what that means is you can only patent something if it isn't already known to the general public. And that makes sense, right? Because you can't go around protecting for yourself ideas which are already out there and which the public already have the benefit of. So you can only protect something if it is new and also non-obvious. But let's look at this new. So if you come up with an idea, and this is a very common myth, is this is my idea, and so it's proprietary to me. I own it, and so if I want to patent it, I can. I mean, that makes perfect sense. But from a legal perspective, it's wrong. From a legal perspective, even if you are the owner of the idea, if you put the idea into the public domain, you have yourself destroyed the novelty. You can destroy the novelty of your own invention. And that's why we talk about this golden rule and why the golden rule is so important. The golden rule is, don't talk about your invention until you have filed a patent application. And in order to sort of bolster this, I'm just going to look at a particular case study. You will have noted how actually I didn't go into the requirement of the other requirements for patentability, about the requirement to solve a technical problem and what that means, and what the words non-obvious mean. And the only reasons that I'm not delving down into that is purely lack of time. I'm focusing just here on what we mean by novelty and why it's so important that you keep your innovation to yourself until you've filed a patent application. So just looking at this case study for a company which I've called Data Sky Limited, because I'm not very imaginative, they have specialist expertise in a particular data science problem. They provide software and services and support to their customers, and they help them to understand their data. So they're providing sort of an analytics tool, if you like, mostly, and I think this is very common for tech company startups, the customers are larger companies. Now, in this particular case, we're looking there at a sort of typical AI pipeline, the kind of thing that's used very often in tech startups of many different applications. The startups developed some core features in its engine, the engine which actually provides the feature set on which the AI model is going to work. Initially, the startup relies on what it thinks are trade secrets to protect the core AI and the analytics engine in their back end. They also provide a user interface and an API. Now, the user interface and API is the bit that's open to the public, right? The bit that the customers are actually going to use. So they go, great. You know, first mover advantage gives them the edge for a year or two. They're providing their analytics services. They're providing support for their customers. They've shown the interface to the customers. The customers have been using the interface, and they've been providing services based on their special AI at the back end. But then over time, the kind of magic starts to dissipate, and the CTO of one of their big customers decides that they can take it all in-house and dispense with the startup company that had the original idea. But they can't do that, right? Because it's my tech, it's proprietary, I own it. And in fact, if you look at this diagram, the confidential ideas are there in dark blue, they're mine. And then the public domain is light blue. Now, I know that I can't get a patent for the light blue bit, I understand that, but certainly the confidential ideas, they're mine. So how can the customer just go it alone? Well, let's look what happened over time from when this startup company started using their innovation. Initially, there were some early discussions with potential investors, probably not under NDA, informal chats with people while they try to work out whether it's a good idea, how they're going to set it up, pitching to customers. So that dark blue is now somewhat reduced because some of their ideas have sort of leaked out in this process. And this goes on. Further down the line, they exhibit at tech events. They release some UI features and they put a new user interface out into the public domain and into their customers. More informal chats. They open up their API, and we've just seen about, you know, the Google Oracle case and what implications there might be for that. And this goes on. This goes on over time, more and more different avenues for destroying the novelty, the original dark blue confidential piece of their own idea. So they've drip-fed knowledge and information into the public domain over several years. in order to run their business right. So they've done this to sell their tech and to serve their customers. However, it's no longer confidential. The customer has now learned enough to build their own back end. The user interface is key, and perhaps the customer is still keen on using the user interface, which was developed by the company, but that's now in the public domain because it's been out there for a couple of years. And the customer copies the interface functionality, but with a different visual appearance. Now, as Paul's explained, even if the interface did have copyright, it would be only in the expression of the interface, not in the functionality. So if the customer uses the functionality in a different visual appearance, there's no infringement of copyright. And things go on over time. Yet more disclosures, drip feeding information to customers. Until finally, through a number of different avenues, the company ends up with really nothing that they could categorize as confidential, maybe 2 to 3 years after starting their startup. Everything's got out there. And actually, if you're looking at the slide, some of these avenues look a little bit left field, but I can assure you they have happened. We had a situation where a PhD student who interned for 6 months included key details of the back end in their PhD thesis. The PhD thesis was then published. Even more interestingly, in a startup company, many of these things can be going on without the right hand knowing what the left is doing, because inherently startup companies are agile. They need to be agile. Everybody needs to be working very fast. Everybody is pitching, everybody is marketing, everybody is developing. And so there's very little coordination about locking down, as Paul put it, the value and making sure that your confidential information is kept confidential. So we end up after a few years with this copyright in the software of a product that's no longer unique in the market, expertise that's no longer perceived as leading edge, no trade secrets anymore because the confidential information has evaporated, no monopoly rights because no patent applications were filed, and therefore significantly reduced leverage in negotiations. And my downwards red line there is simply supposed to indicate that the loss of value in the IP because of the behaviors of the startup. And the startup was doing nothing wrong in terms of their business strategy. Let's assume that the product was highly successful and the startup's been highly successful with its sales. So successful that the customers now want to copy it. But they did do something wrong. They didn't patent it, but they can still patent it, right? No. And that's because of the golden rule. They have destroyed the novelty in their own invention. The user interface functionality is no longer new because it entered the public domain when the startup released the product. The core engines are no longer new because they've entered the public domain through the actions of the startup. All of these bits of the dark blue in the middle of the slides have been disseminated through these different avenues of marketing, pitching, tech events, putting things into theses, etc. So you can't patent it. Now, the scenario could have been quite different. If they'd applied for patent protection before the user interface and the core analytics method entered the public domain, then they would have been in an entirely different situation, because then they would have filed the patent application before the novelty of their invention had been destroyed by themselves. They would now have some patent applications or some patents actually granted. That would have leveled the playing field in negotiations with their customers, advertised and defended their innovation. And note here, their first mover advantage would still be maintained, because even when you file a patent application, it does not become public for 18 months. So any patent application is kept secret by the government authorities for for 18 months after the filing date. So you still have your first mover advantage, even if you file your patent application when you start your innovation. Don't wait until it's too late. So I'm going to hand back to Paul now, and also to see if there's any questions. But I did just want to address one or two points which Paul made, because I think he promised that I would. So he referred to use of trademarks, and you require use of a trademark in order for your trademark to be valid. But you can actually apply for a patent even if you don't use the invention yourself. So if you have a good idea, you can still apply for a patent even though you're not the one that's actually going to use the idea. So at this point, I'm going to hand back to Paul and ask for any questions. Thank you very much.
Yeah, thank you very much, Virginia. So that's hopefully that's a really good, rounded picture of the protection and how you can unlock the value in IP and how you can destroy that value more particularly. So just make sure you don't. At the moment, we don't have any questions in the Q&A, but I don't think we do. If you've got anything, do let us have those or follow up afterwards. But can I mention a couple of things? Firstly, so Page White and Farrer are involved in the Northern Tech Awards, which take place on the 9th of November at New Dock Hall in Leeds. And Virginia is one of the judges on that. She was hoping that today was the last day for putting in entries, but it was Monday, so
It was just extended, Paul.
Oh, have they?
It was extended. It was just extended until today. Today's now the last day.
So if you've got something,
you've still got a chance.
get in there. The other thing is Leeds Digital Festival, of course, is ongoing. It's ongoing until the end of next week. We've got a couple of events at the end of next week, which you may well be interested in. So on Thursday morning, we have an in-person or hybrid event. So it can take place. It'll be taking place at Platform, here at Platform in Leeds, jointly with Garb & Elliott, Chartered Accountants, and that's on investment readiness. So that hopefully will be really interesting. So we'll both be able to do that online and in person. So in case you wanted to know what a hybrid event looks like, well, we're going to be trying it. We have trialed it already, so we think we can do this. And the last thing, on the last day of the festival, on Friday, we have our festival run. So this is the third time that the Berwins have hosted the Leeds Digital Festival run. It'll be for those who are either very keen runners or more casual runners, this takes place around some of the digital locations within central Leeds. It's probably only 5 or 6 kilometres. It's at a very gentle pace. It is not a race. Nobody gets left behind. We're doing it in conjunction with Up and Running, who will make sure that we're safe as well. So if anyone on the last day of the festival, Friday morning, 8 o'clock, fancies joining us, then you'll see details on the website for the Leeds Digital Festival, also on Berwin's website, and you will be really, really welcome. First time we did it, we had this was a new concept. We had 30 odd people doing it. Last year we did it, and of course we were in lockdown at the time. So 2 of us did it, 2 of us from Berwins. This time, I think we're going to have loads of people doing it. So if you can join us, that will be absolutely great. That's all for us now. Oh, hang on, it's not all for us now. We have a question. Right. So I think this is for me. So what happens when you have the domain name, but other people are already using the name in their business but have not trademarked it? So if people are using the name, so the domain name doesn't give you any priority rights, because as you'll know, you can have all sorts of different versions of domains, because it can, it can be a .co.uk or a .com or all sorts of different things. That doesn't give you protection, doesn't give you rights to that name. If people are using the name in their business but they haven't trademarked it, then they haven't protected it. So you should be able to use that, though that does depend on the extent to which they are using it. Because one of the unregistered rights is a passing off right. So for instance, were McDonald's not to have registered a trademark, but everybody in the world knows that McDonald's are those burgers, then somebody else started using that same name, then McDonald's would jump on them to say, hang on, we've got an established goodwill in that name, we can stop you using it, and they would be able to. It's not as powerful as having a trademark registered, because a trademark is registered against anybody in the country where it's registered. So you might have, for instance, let's just take this example. So for instance, in Otley, there is a pie shop called Weigmans. Now, if somebody else in Otley or in the vicinity of Otley or in that kind of area started calling themselves Weigmans, then Weigmans would be able to stop them on a passing off basis. But if someone in Cornwall started calling themselves Weigmans, they might not do, because Weigmans wouldn't have an established name in that area. So had Weigmans, and maybe they have registered, but if they have a registered trademark, then they will be protected wherever they are in the UK. But if not, then it's only protected within, it might be the location or the industry or the area in which they are well known. I hope that explains that, but I'm happy to have a chat about that if anyone wants. Okay. Thank you. So I think I just saw a slide with the events on. There we go. So yeah, that's a slide there with the events on that we've got on. So getting your tech business investment ready and the Leeds Digital Festival run. So if you'd like to join us in any of those, please do so. I think that is all. Any more questions? No. Good. Okay. Thanks very much, everybody, for joining us. I hope that's been valuable, and hope you can join us in other events in the future. Anything that we can help with, either Berwins or Page White and Farrer, Virginia, Tom, myself, my colleagues, we'll be happy to help you. Thank you very much indeed.
Thank you.